With respect to the JLSC and the current crisis that faces the judiciary, where the unpleasant fact is that there are persons who are incarcerated and whose cases cannot progress through the law courts because of recent developments which I need not detain you with. And I had indicated publicly a while ago, I think it was at a press conference at the airport, I indicated that I had been given some low-level advice or non-rigorous advice that this matter may end up in the Parliament. I indicated to the opposition leader then that in consultation with the Attorney General, who had been in consultation with elements of the judiciary, mainly the DPP and the Chief Justice, the Attorney General had come to me with proposals coming from the DPP indicating that the solution to that problem that now exists could be legislative, and there could be a requirement for the Parliament to meet and legislate amendments to the Summary Courts Act and the Preliminary Inquiries Act, so that the problem that now exists, as I outlined a while ago, of people not being able to have their matters heard, could be dealt with. The opposition leader made it quite clear that the opposition is not prepared to support this approach because they do not believe that that approach is sound, and there will be more problems created than solved because people who are affected have already begun to challenge the situation, and that there are certain rights and privileges and protections to which they are entitled, and this arrangement of having the DPP intervene and make rulings and interventions to make fits and starts would trample on some of those rights. And it is the view of the opposition that whatever we legislate will be open to challenge, and the opposition leader buttressed those arguments against the judgment of the repeal of Section 34, which succeeded because certain conditions existed, and it is her view that those conditions do not now exist, and we would fail if we try to do that again. And therefore, they are insisting that we look for a solution under Section 137, where we determine the full nature of the problem, because the opposition, like the rest of the country, does not have answers to questions as to who is the chief magistrate, whether a judge exists, whether the judge is being paid, if a magistrate is being paid, who is acting, who is giving these instructions, and all kinds of complications. So we had no agreement on that. What we did have is an agreement that the Attorney General will continue to consult and will consult with the opposition on this matter, and I will have to take my guidance from elsewhere.